So in the last class, we have discussed about the remedies for breach of contract, and therein, if you can see the this particular slide on the right side. So it talks about. Give me a second. Let me increase the width. Yeah. So if we talk about the remedies for breach of contract, so we have discussed the meaning of breach of contract, and also we have discussed about the what are the possible remedies available with the plaintiff, or if there are certain kind of certain issues, or the other person has not performed. So what are the possible remedies available with him? So in this case, breach of contract, we have discussed the meaning of breach. We have discussed about the actual breach and anticipatory breach. We have also discussed about that what are the options available with the person, aggrieved party, in case of anticipatory breach. Either he can wait for the exact time of the performance, or he can consider the contract as terminated, and he can file the case that time only. So after that, we have discussed about the damages and the other options available with the particular person who is the person who is not guilty. So there we have discussed about the damages in terms of that when there is a non-performance or party has refused to perform, the other party has the right to go to court of law to sue the other party to claim the damages, and these damages can be in form of ordinary damages, special damages, nominal damages, or exemplary or vindictive damages. So when we talk about the ordinary damages, so as already discussed, that ordinary damages talks about the difference price on the date of committing the breach and the market price of the particular commodity or subject matter, and that particular difference is considered as the ordinary damage, and as a matter of right, the aggrieved party can file a case in the court of law to claim that damage. Then after that, we have discussed about the special damages. So special damages are incurred because of certain non-performance, and these special damages can be claimed only when this particular loss has already been communicated to the other party, that non-performance is going to lead with this particular special damage. And here we have also discussed that if there is any kind of situation where these damages, special damages, are not known to the other party, then these cannot be claimed as a matter of right. Then after that, we have discussed about the vindictive or exemplary damages. So when we talk about the exemplary damage, so it means that any kind of damage which the other party has suffered, it is the monetary loss, but along with the monetary loss, the other party has suffered some mental agony or certain mental suffering. So then in that particular situation, vindictive or exemplary damages are allowed. And as per the law, in as per Indian Contract Act 1872, this has vindictive damages is not part of it. But in case of if there is a breach of a contract to marry, or there is a wrongful dishonor of a customer's check, then in that case, vindictive damages can be claimed under the Indian Contract Act provisions. Then we discuss about the nominal damages. So when we talk about the nominal damages, in case of nominal damages, the person is not impose the any bigger amount of damage or loss, or the person has not suffered the loss actually, but these damages are imposed to make the other person realize his mistake, that this particular damage is to be paid in case of non-performance. So in this particular case situation, nominal damages can be claimed only when the party has not suffered actual loss or damage, and the or the party has not able to prove that there has been certain kind of loss, or the actual damage or loss which is there, it was more due to the default of the aggrieved party, and not about the because of the act of the defendant. So in this particular situation, if the particular person has suffered this loss, or this particular non-performance, the person has not able to determine the loss, or the other person is to be realized his mistake, then in that case nominal damages can be claimed, and these can be imposed by the court of law. Now in this case, if we talk about the rules regarding the claim of the damages based on the provision under section 73 to 75, so therein we have to understand that this particular situation where we talk about the damages arisen from the because of the non performance, there we have to talk about the what are the rules regarding we claim of the damages. So when we talk about the rules regarding claim of the damages, then in that case we have to understand rules to claim damages. In that case, we have to understand that these damages are has arisen naturally. Naturally means that out of the breach of the contract, say there is because of the breach of the contract, because of the non-performance, the damages came naturally. So there was no intention, or the other person has not created that loss himself. But when the non-performance has happened, the other person has suffered these particular loss or damage. Then damage, we talk about the in case of the special circumstances. So as per the rule, these special damages cannot be recovered. Special damages can be recovered only subject to condition. Can't be recovered as a normal course of action, as a right. So these can be claimed only when the particular situation has been fulfilled or the condition has been fulfilled. There is no damage in terms of indirect or remote loss. So if the loss is there because of any indirect cause or the remote cause, so in that case we talk about that this damage cannot be covered as a matter of right. Similarly, if the damages are compensatory, then only these can be claimed. If it is in terms of the punishment, etc., then these damages cannot be claimed. So if there is any kind of compensation is received with the along with the damage, then the court of a law will allow as per the rules. Otherwise, these damages cannot be claimed if these damages have been imposed as a punishment. Then the damages not allowed where the party has not suffered the loss. So we said no loss, no fraud, or if there is no loss, then no damages can be claimed. Other than that, the first party should have exercised to mitigate the loss. So whatever loss is being suffered, the other party has tried to mitigate that loss. For example, if we talk about the insurance case or the other situation, so where the loss is being suffered by the party, so in that particular situation, the person, if there is a fire broke off, the other person has tried to mitigate the fire. It's not that he has allowed to the loss to be at a level because it is already covered by the insurance. So mitigation of loss is we talk about the rule that the person is can claim the damages or have the right to claim the damages only when he has put best of his effort to reduce the possibility of the loss. Then if there is a situation that there is a difficulty of assessment of loss, then in that particular case, the court must decide or give the decision in terms of measurement of the damages. So in case there is ordinary damage, the measure is there, or there is any other kind of loss, the measure is there. But in certain situation, if there is difficulty in assessment of damage, then in that case the court or decision of the court would be the final one. Then if we talk about the even for the physical efforts, or if there is any kind of the mental suffering, etc., then there is no damage is allowed in case of when the party is aware that this is particular damage will be there, or the mental suffering will be there if there is non performance, then for that the damage can be claimed. Otherwise, with respect to the mental suffering, physical inconvenience, discomfort, the damages cannot be claimed. So that's why we say that in case of breach to the of promise to marry, or in case of dishonor of check by the bank, wrongful dishonor, there is the damage is allowed. Otherwise, in normal circumstances, if you got hurt in certain situation, that particular suffering is not covered. Then there is, if there is a breach in case of sale, so we are going to discuss this particular thing in the case of sale of goods act. So if there are certain cases where the contract of sale is there and the other person has not performed, so there are certain rules which are governed by the sale of goods act as the remedies for breach of contract. And there are certain situations which are known as quasi contract, which we are going to discuss in the coming classes. So if there are certain kind of non performance in case of quasi contract, so damages remains the same as these are in the case of normal contract act. And with respect to any kind of inconvenience or discomfort, damages are not allowed. So when we measure the damage or we talk about the damage, we need to understand or we need to remember these points, that these are the things which will be the rules which will govern the amount of damages or amount of loss or the remedy to claim the damages in a particular situation. Then after that, we have also discussed about cost of decree. We have also discussed about liquidated damages and penalty. So all these things we have already discussed. Now when we move forward to further kind of remedies, so there this thing we have already discussed, right? Liquidated damages and penalty, etc. We have also discussed. Then we have to discuss about section 74, that in case of default, payment of interest at a higher rate can be the penalty or can be one of the cause in particular situation or in particular circumstances. Then further, if we go to the other form of remedies for breach of contract, then we can discuss about the suit for rescission and suit for quantum merit. Then let me discuss this one as well. So when we talk about the remedies for breach of contract, so in the remedies, the first one we have discussed as the suit for rescission. When we talk about the suit for rescission means setting aside the contract. The party has right to set aside the contract. So in this particular situation, when one party shows the non-performance or there is actual or anticipatory breach, the other party has right to go to court of law. So in that case, the suit for rescission can be filed when there is a contract is voidable at the option of the other party. So when there is the contract is voidable, it means enforceable or not enforceable at the option of one of the party, then suit of rescission can be filed. And if there is any contract which is there is the any unlawful thing is being added, or there is any unauthorized alterations are there, or there is the reasons are not clear that why the other person has not performed, so in that case the party can file the suit for rescission. And when the party has filed the case with respect to setting aside the contract, then in this particular situation the party is discharged from his legal obligation. तो जो भी उसे एज अ पार्टी उस पर्टिकुलर कॉन्ट्रैक्ट के अंदर परफॉर्म करना था, तो वो उस पर्टिकुलर कॉन्ट्रैक्ट के अंदर उसकी जो लीगल ऑब्लिगेशन थी वो उससे फ्री हो गया, एंड ही कैन नॉट be held liable for non-performance. So it means that the party has got free from his legal obligation. Then also the party, the aggrieved party who is not at loss or who is not at fault, who is not at fault, so he has the right to take legal action against the other party. Take legal action against the other party who has committed the breach of contract. Then in continuation, the particular person who has rightfully set aside the contract, then he can claim the damages, he can claim the quantum merit, he can claim the specific performance. So when we talk about the second right, that is suit for damages, this we have already discussed in detail with respect to types of damages, how it can be claimed, or what are the different rules. The third remedy comes as suit upon quantum merit. When we talk about this particular rule, it says that this particular rule applies, or this particular, we can talk about the remedy is applicable in case where the particular contract is in continuation, where part of the contract has already been performed, part of the contract or performance has already been rendered, so when we talk about suit upon quantum merit, it means as much as earned. तो अगर किसी पर्टिकुलर कॉन्ट्रैक्ट के अंदर you have already performed or you have already given the performance for part of the contract, then in that particular situation you can file a case with respect to quantum merit, wherein you have the right or you have the entitlement to receive the payment for the a part of the contract which have been performed. So you can draw the payment, or you can file, or you can claim the payment for performance done. Here we can take an example of, for example, A has entered into a contract with B that B is going to perform every weekend at his restaurant, right? And he's performing, he's doing this activity for past 2 months, and after 2 months A has suddenly refused that you don't need to continue with your services, right? So there is breach of contract. The contract is for contract was for 1 year. He has engaged B, might be a singer, right? So he has engaged B for 1 year, and after 2 months A has committed the breach of contract, that not to continue. So in that this particular case there is non-performance by A. So in this particular situation B has a right to claim the payment or file a case against A with respect to quantum merit, where he has worked for this particular time period, and after discontinuation he is entitled, or he has got the right to receive payment for the portion of services, quantum of services for which he has already rendered. So this will be known as suit upon quantum merit. There can be one situation also wherein we can talk about say that the part of the contract was not acceptable, or it has not been performed up to the mark. So in that particular situation, if there is an agreement where the it is void or it has become void, or where the particular party has not performed it well. So there this particular quantum merit suit can be filed. For example, the goods have been supplied, and instead of the quality of 100%, the goods were not up to mark, and goods were 80% okay. So in this case, the person can reject the contract or set aside the contract, but the goods which were 80% okay, or 80% of the goods have been delivered, so for that the payment can be claimed, or the suit can be filed by the other party. So this is called as suit for quantum merit. So if there is, the contract is divisible, so the payment can be claimed for the divisible part. And if the contract is not divisible, or where lump sum money has been promised, so in this particular case, the part performance, for a part performance, will not entitle party to claim any performance. So if the goods are not divisible, so in that case, you and the goods were defective, or there is a machinery, and in this particular machinery did not work because one component is defective, and that component cannot be replaced. If this component can be replaced, for remaining part of the machinery, the cost can be claimed. But if without this component, this machinery is not workable, it is not divisible, so then in that particular case, whole of the contract will become void, will not be performed, or will not be enforceable by law. Then after that, in continuation of remedy, there comes the fourth remedy, which talks about the suit for specific performance. As already discussed, that when we talk about suit for specific performance, so in certain situations, there is the possibility that the damages, or we can talk about the monetary compensation, is not an adequate remedy. Monetary compensation is not an adequate remedy. Or there can be a possibility that there is the damages cannot be determined. Damages can't be determined. So in this particular situation, the court may allow, or plaintiff may file the case for the specific performance where the party is required to perform under the contract. The party does not have the choice not to perform. So court may grant compensation in terms of the specific performance only. So here, this is already discussed. Then in specific performance, that where the damages are not adequate remedy, the court may direct to the party in breach to carry his promise according to the terms of the contract. Then if there is no standard for determining actual damage, or compensation in money cannot be got for the non-performance of the act agreed to be done, so in all these situations, specific performance would be granted. Then specific performance will not be granted in situation where damages are adequate remedy, where the contract is inadequate or uncertain, where it is revocable, where the contract is made by the trustees, and in case of breach of trust, we cannot compel the trustees to perform the contract. And in case of contract of personal nature, marriage nature contract, so if a person have already married someone else, so you cannot say that to break that marriage and marry some one person, so that is not possible. Then in case of contract of companies, body corporates, which are beyond the object of ultra-virus, so there the law restricts the performance, there the specific performance cannot be granted or cannot be claimed. Last one is suit for injunction. So when we talk about the last remedy, so that's last remedy is known as suit for injunction. When we talk about Suit for injunction. So it's a kind of performance only, because when we talk about the meaning of contract or meaning of consideration, so we say promise to do or not to do something. So when the particular promise is in terms of abstinence, in terms of restrictions, then to impose these restrictions or abstinence would be called as suit for injunction. So it is a kind of performance only. So when there is a promise not to perform something or restrict something or not to do something, so in that case, if this is being allowed or the other person is performing that, so the court may order to restrict or to refrain from that activity. So this would be called as suit for injunction. So if you remember, so in case of transfer of goodwill, you are restricted not to carry on the business in the same name or within a same time period. When you are in a particular service and there are certain conditions that you are not allowed to join other service, or if there are any other kind of promise in terms of not to do something, so in that case, if the court restricts, so that restriction is in terms of the performance of the contract, but because it is in terms of abstinence, so it is called as suit for injunction. So there is one more possibility, that if we go to court of law and if we want to change certain terms and conditions, or certain difficulties are there in terms of the performance, so we can also file a case with respect to rectification or cancellation. So even now when we talk about the discharge of contract, so there we have discussed in terms of mutual agreement, where we have discussed about the novation, waiver, or if you remember, in terms of merger, in terms of cancellation. So we have already discussed all these things. So this particular case can be filed where the parties by mutual mistake have entered into the contract, and certain clarifications are there, and you want to perform or not to perform the contract. So you may plead the court of law with respect to rectification or cancellation of the same. So if we talk about this particular topic with respect to remedies for breach of contract, so I think all the topics we have covered till now. So if you have any queries, we can take up all the queries